Hello, good night. This is U.S. immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Tonight, I have a good topic to talk about, and that is how soon after marriage can you apply for the green card? So that is a common question that I'm getting that I think it's important for us to talk about because I don't want you to wait too long and at the same time before you apply. And I want to make sure that you understand what it's going to take and how you need to prepare for this. So when you are how soon after marriage can you apply for the marriage-based green card? And the answer is you can apply tomorrow. You can apply the day after. You can apply the day after, or even on the day of your marriage, as long as you have that marriage certificate to show that you're legally married. However, even though there's no time limit on when you can apply after marriage, you can apply immediately after marriage. The only other issue is, do you have the evidence to support an approval? That's going to be the real question, and that's the most crucial part about this process, more crucial than ever. That's because no, previously it was never the case, but previously, people had the idea that you got married, you got the green card. And now what is happening is they are now putting in, during the process, they are putting in the possibility of issuing a notice to appear in immigration court if they look at your application, they deny the application, and maybe even in some cases they reject the application due to mistakes. They can issue a notice to appear if you've already overstayed. So it's important more than ever not to make mistakes, to understand the procedural requirements, make sure you're submitting everything, including the evidence, because lack of evidence is the number one reason why these applications get denied. So you definitely don't want. I would say there are three things that you need to make sure you're paying attention to. Evidence. You need to show legal proof of your marriage. You need to show your marriage is real. Those are two separate things. You need to show it's legal, but also it's real. You also have to make sure your evidence showing it's real is sufficient. And in addition to that, you must make sure that affidavit of support is solid. It's a part of the documentation and the process that's it's very much overlooked. And when it's overlooked, now they are not approving without that affidavit of support. And they have said that now and I did see that, and when I practiced in the last administration, that's exactly what they did. They would deny on first shot. If you didn't get the affidavit of support right, denial without chances. We are going to be seeing a lot more of that again. So make sure that that affidavit of support is solid. And make sure your medical is solid. Make sure you do meet all the requirements for your medical. Hi there, Josiah. It's nice to see you way up in Fargo, North Dakota. So it's all about how is this submitted. Now, another thing is interviews are coming in record time, marriage-based interviews. So they are definitely coming fast. Now, people will say, does that mean and that is a pattern we're seeing lately. Marriage interviews are coming fast. So there is no time to be saying, I'm going to submit that later. I'll rush and file it now, and then I'll just submit the rest later. You may not have that opportunity, right? I mean, unless a deadline is coming, unless there's something crucial, some deadline you need to meet. But you must make sure that before you submit that, it's submitted, it's properly done, and you are ready for the interview, right? So keep that in mind. And it is going fast, right? I just spoke to someone else who has got the green card in a week. So got the green card in a week, right? This was not a client, but this was someone I just happened to be talking to, and that person got the interview on the 28th and just got their green card yesterday. That's how fast. And they had applied earlier this year. So it's moving fast, right? So, and we are also getting interviews too. So we're getting interviews fast. And we've even seen that with the asylum. So we are getting marriage based interviews quickly. And then don't look at those interviews as, don't look at it uh, as something that's going to be a red flag or it's going to be something bad. You need to look at it as an opportunity. It's an opportunity. For example, in our cases, we don't just take cases, losing cases. We don't take cases to that we plan to for it to fail. So when an interview comes, it means our client is going to get to the solution faster because we're going to make sure our client is prepared, our client goes in and gets what they need to get. So keep that in mind. So thinking about marriage based, you need to make sure that you're submitting it in a solid way so that when it gets before the officer, that they don't do denials, they schedule that interview just to confirm that this is an approvable application and you get through. How things go wrong is it's not submitted properly. You get a notice to appear in immigration court, and now they're no longer considering your adjustment of status. You are going before a judge where the judge may consider your adjustment of status. And now it's hard to go back to just go back to an affirmative application. Now you're in defensive mode. You're fighting deportation at the same time that you're trying to get your green card through your spouse. So do it right. Do it right the first time. And I have been stressing this because I really want you to understand how essential it is. I am seeing a difference in people who are represented by attorneys. And the reason being, right now, the process is strict. The policies are getting stricter, and it means that you need to have someone who understands the procedural steps, requirements, understands strategically what will happen if this happens or that happens. It's more crucial than ever for you to be able to have that assistance. With the individual I was talking to who got the green card, here's the other thing is in their case, they had an issue with immigration at first because they hired a non-attorney, right? So they hired a non-attorney, and the non-attorney messed up their paperwork, right? So she got a nasty letter from immigration, and luckily she was able to fix it. But how did she fix it? She had to hire an attorney. She had to hire an attorney. So and everything started to go well from there, right? So keep that in mind, that it's important to have that assistance. Make sure you're doing it right the first time, because her situation could have ended very badly. And fortunately, she acted very quickly, got it fixed, and now has the green card. So that's just a tale to let you know that how important it is to understand how to proceed in your process. And that's what we're here to do. We have had tremendous successes in our marriage-based cases. We have yet to have a denial in marriage-based cases because we are very detail-oriented. We make sure that we understand what needs to be submitted based on the couple. It's not a one size fits all. So you don't look at the other couple and say they got approved because they did this. I look at the couple in front of me and I say, okay, who are you as a couple? And we present the evidence in an authentic way that the officers can look at this and they can say, okay, they're a real couple, they're building their lives together, because we do it based on that couple. So, this is where huddle, make sure you get the help you need, and then we get started on your process. And we're here to do that for you. It's one of our favorite case types, and we do it well. So get in touch with us so that we can get started, do it right, do it once, and get you that green card, right? Hopefully quickly, because some interviews are coming quickly, and we are now seeing that in the office as well. So we are seeing interviews coming quickly. All right, so now I'm going to answer questions. Go ahead and put your questions in the comments so that I can answer your questions. I'm going to start on Instagram tonight, and then I'm going to make my way over to TikTok. So in the meantime, put your questions in the comments, and I will go ahead and get to those as soon as I make my way across. All right. My U.S. citizen husband filed for my 13-year-old daughter in May 2025. How long will that process take to be approved? So it depends on where your daughter is. If your daughter is outside of the United States, you're looking at about a 2-year process. If she's in the U.S., maybe a year to a year and a half. Maybe less too. Keep in mind that once again, we are seeing processing times moving. I would say, it's not so bad right now, right? But where things can go wrong is where you go to that interview and something is messed up, or it's messed up in the documents that you're submitting. That's where things go south and your process can take longer. Now, it's not a guarantee. I'm just going off of the trend that I'm seeing right now, the trend that I'm observing, but it's not a guarantee, and it's not me saying that I have the inside knowledge from immigration's perspective, but that's what I'm seeing. All right, let's see. Okay, she's outside of the US. So yeah, I would say I'll expect about a 2-year process, unfortunately. When you're outside of the US going through consular processing, at the longest time is waiting for the interview. So once you're documentarily qualified, so your spouse filed for her in March, it's about a year and a half to get the decision. Then once she gets a decision, it goes to the National Visa Center. Here's where you definitely need to be on top of it, because National Visa Center, it's very easy to make mistakes. One mistake costs 3 months delay. So if you're not careful, your process can go from a 2-year wait period to sometimes 3 years, because one mistake, I often observe this, one mistake equals 3-month delay in your process. Actually, no, sorry, not 3 months, 6-month delay in your process. And the reason this is the case is because once the petition is approved, it gets to the National Visa Center. The National Visa Center is like the liaison between the embassy and the family of the immigrant. And what happens is they are going to say, upload all the documentation we need to go ahead and approve you for and to schedule an interview. And that's where a lot of people go wrong. They submit the wrong documents. They don't understand the requirements. The documents aren't formatted correctly because they're very strict on how documents are presented. They upload the document, and then NVC doesn't get to it until about 3 months later. They look at it and then they're like, oh, no, sorry, it doesn't meet our standards. You have to resubmit this document, or they'll tell you what to correct. and you go ahead and correct it. Lord knows how long it's going to take you to correct it, but you go ahead and correct it, you re-upload it, and then you're going to hear an answer in another 3 months, right? For them to confirm, okay, it's good this time. Now, God forbid you make another mistake. So that can go on and on and on. I did have one client who hired me because it was such a nightmare. She and her spouse tried to do it by themselves and they struggled for 2 years straight. 2 years. So from 2019 to 2021, they struggled to get it right. And it was really simple, but not simple for somebody who didn't understand the process. It was really simple for me because that's something I do every day. But for them, they're not attorneys. They didn't understand the procedures. They didn't understand the format, why things had to be formatted a certain way. So they struggled for 2 years straight, but just on one document that they had to submit. Once we came into the picture, got fixed, client got interview, and then it went by very quickly. Things went quickly after that. So the lesson here is just understand. That's why it's important to understand the procedural requirements, but understand how mistakes can, cause a lot of issues in your process, a lot of delays, unnecessary delays. Why, if you're married to a US citizen and didn't file your paper and then divorce you? I guess, what if you're married to a citizen, didn't file the papers, and then divorce? So I guess I would have to. I guess, is there more? I would have some follow-up questions. What are your plans? Do you plan to remarry and then file documents with your new spouse? Usually, yeah, you do have to disclose that you were married previously. They don't usually look to see if you didn't file any papers, then, there's really nothing for them to look into per se. But if they do have any other knowledge that maybe somehow the previous marriage was suspicious, maybe it might open up the door for questions. So I guess I'd have to figure out, okay, you married a US citizen, you got divorced, you never filed papers. That happens every day. Um, and since you didn't file papers, it's really not even on file or a concern of immigration. So what are your plans then following up? Do you plan to file? What are you concerned about exactly? Um, one of the things they are focusing on is fraud. And if they see anything in your divorce that indicates some form of fraud, or something suspicious, then that's where I would have to hone into that. So that's where I say, if you have any questions, if you have any gut feelings, anything, just do it right and have an attorney guide you through it. Okay. So I think that's it on Instagram. All right, so that's it. I'm gonna head on to TikTok, and then I'm doing YouTube and Facebook. So hang tight, everybody. I see you. Okay, so how long is I-751? Expect up to 4 years right now. My cases I've seen as short as 2 years, as short even as a year and a half. But many of them are going on an average of about 4 years, and that's why they issued the 4-year extension. U.S. citizen, parent, sponsor, adult, unmarried, child, priority date 2018, case NVC. How long again for the green card interviews? Okay, so if the case is at the NVC, I would say a year and a half to 2 years right now, wait for interviews. How long do one have to wait for EAD when you file for VAWA? 6 to 12 months. I have an I-751 and my N-400 interviews coming up on Tuesday. So keep in mind here, when you're filing for removal of conditions and citizenship at the same time, removal of condition means you're going from a 2-year green card to a 10-year green card. And then you then come up for qualification for citizenship. You need to go in and be prepared. It's going to be a necessity that they do an I-751 review first, and then they may, if they don't have any additional questions in that about your I-751, they approve it, then they may go on to the N-400 interview, right, for citizenship. Once they do that, it means, you're good. So you need to be prepared for both of them. You have to bring your evidence, and then keep in mind too that now with naturalizations, they are taking a closer look at good moral character. So make sure you're going in with your employer's letters from maybe people in your community. Maybe if you're close to the neighbor, see if you can get a character letter from your neighbor, your employer. If you have other people in your community that you are close to, or that you even know that you have a good relationship with, get those letters. You need to shore up those things for the appointment, because they're going to be looking at things like that now. Is a biometrics appointment a target for immigrants? So one thing I would say is, if you're applying for a benefit, you're not going to get approved on your documents unless you do the biometrics appointment. Now, I would say typically it's not. We have our clients are still going, we have many clients that are going for biometrics. We have had many clients going for biometrics from the top of the year. And, it's been fine. However, if there's something in your background you're concerned about, if there's an immigration warrant out, if you have a removal order that has been placed on you a long time ago, in that case, you need to get legal advice before doing that. No, but keep in mind, you're not going to get to the approval if you don't do the biometrics. All right, so I'm on TikTok now. I was on YouTube and Facebook, so I went ahead and did that first. So now go ahead and put your questions in TikTok. I'm going to scroll through and start answering questions. Do they look at the petitioner background for I-485? Absolutely. That's what is mostly what the I-485 is all about. I'm a green card holder. Can I file for my son and his wife and also apply for change of status? It may be possible, but this is where I say be very careful, because you're a green card holder, that your spouse, no, okay, wait, no. Okay, you're a green card holder. Can you file for your son and his wife? No. You cannot file for married children. Only US citizens can file for married children. So that is not a possibility. How long does it take for a U visa to be approved, for deferred action to get protection? You get your EAD, you're looking at about 1.5 years for that, after applying and applying properly. Good night. Can you file for asylum after being in the US after 9 years? I would say it's a possibility, but it depends on what were the circumstances that caused you to apply 9 years after entry. If there were changed circumstances in your country, like for example, when you came here 9 years ago, none of those conditions that caused you to fear going back existed. But maybe now those conditions exist in your country, and now if you go back, you're definitely going to be in trouble. It's time to look at asylum as an option. You can give us a call and let's talk. What if the spouse is denied the I-485 and decided to run away from the marriage, no contact. So that depends on your facts. If they, I mean, on if the immigrant spouse was denied and then they left the marriage, it really is more a question of what do you want to do? You want to divorce them? What do you want to do? I don't know what if the immigrant spouse left the situation after it was denied. I'm not sure what you would want. Are EB4 visa bulletin gonna be released? It could be, yeah. So it could be. It just depends on when things are gonna open up for that again. I want to remarry someday. My question is, since I divorced many years ago, do I need to report? So if on the immigration papers they're asking you for your marital history, you have to. Is it safe to file for a mandamus after 2 years waiting? That really is a very specific question, and it really depends on processing times, right? So, for example, say with VAWA, after 2 years of waiting for VAWA, VAWA's processing time is 3 years, 3.5 years. So, filing a mandamus just based on the processing time there may not be sufficient. But you may be facing certain circumstances or hardships that really justify a mandamus. So it really depends. Um, so I became naturalized citizen about 11 years ago, and I divorced while finishing my process. So if you're a naturalized citizen, you don't have to report anything. But keep in mind, it sounds like there's something you're concerned about, get legal advice. Because if you're a naturalized citizen, you divorce about 11 years ago and you divorced while finishing the process, did you not tell them that you were divorced? Did the question come up and you didn't disclose that? So, did you represent to them that you were living with your spouse when you weren't living with your spouse? You're already a citizen, but if that ever came up in the future, then or if they reevaluated your application, saw anything like that, that may be an issue. So if you're concerned about anything, get legal advice. Is there any way to file for out of status children in the US? 10-year-old, green card, 19 and 17. It's possible, but I'd have to. So there is what's called SIJS. If they're out of status, they're without parents, the parents have abandoned them, then that may be a way to move towards a green card, but I'd have to learn more. Definitely give us a call and talk to us, and let's explore some options. There may be adoption as well. So there may be, but I'd have to understand what your circumstances are. How long does I-130 take to approve? It depends on the category you're in. I've seen it from range from 4 months to over a year. How long does it take to get your work permit approved after biometrics? Well, we just got one work permit approved within a week of the biometrics. So that tells you that it can be in a week. It could be, I've seen a week, I've seen 2 weeks, but I've also seen it much longer. So months long, even a year long, just depending on the case type. The bank's trying to sue me for a used car that I've returned because it was, so that is not going to be me. That's going to be maybe like a creditor's rights attorney, or yeah. So search for I forget what it is right now, consumer rights attorney. So that's going to be a consumer rights attorney. That's not going to be me. Now, keep in mind if you're being sued and you're going for citizenship, that may be a question that you have to answer because outstanding debts may come up in a citizenship interview. Can I file for my sibling as a US citizen? They all have US visa, B1, B2. You can file for a petition for your siblings, but it's a 14-year wait period. So even if they came on a B1, B2 visa, there's no way they're going to sit here with a B1, B2 visa for 14 years. They're going to be out of status, get stuck, and they're not going to be able to get to their green card because they won't, once they overstay, they won't qualify for adjustment of status. So they would have to stay in their countries for the 14 years, if at minimum 14 years, by the way, before approved. So it's not, in other words, sponsoring your siblings while they're here in the US is not going to fix or allow them to stay here and get the green card. Hi there, Felicita. It's nice to see you. Anyway, you can help F2 holder get work permit, or how should I go about it? F2 cannot, they don't qualify for work permit, the F2. So F2 is usually like the spouse or of a student. And now, if you want to look at other options, give us a call. We'll see if you qualify for other options. Thank you for the love. Thank you for the likes, the shares, the follows. That is very helpful, and it's helpful to get the word out there that I'm here giving good information, answering questions. And it also helps to empower immigrants through their immigration journey, getting this information. So thank you for the love, and keep it coming because it helps other people as well. All right. So let's see. Thank you. These are all great questions. How long will it take? I-130 for spouse outside of the United States, and I'm a citizen, so expect about a 2-year process. How long I-130 freedom of information request take? The I-130 was filed in, so sometimes they put it in the simple track and you could get it in 2 to 4 weeks. If it goes into the complex track, then you could be looking at more than 4 weeks to get it. If you overstay, can you file adjustment of status as a spouse of a US citizen? Yes, you can. Absolutely. Give us a call. We can help you. That was what this whole today, what I talked about was about. How long do I have to wait for the green card? It depends on what category you're in. So I answered that. I have a green card. How long do I have to wait before applying for citizenship? 5 years generally. If you are currently married to a spouse, you're married to them for 3 years, you have your green card for 3 years, then 3 years from the date of your green card approval. Can a green card holder just adjust his husband's status who is on H-2B? Great question. That is possible. If they're on a current H-2B, the priority date is current. And so this is very strategic. It can make a difference to definitely talk to us, because we would be able to guide you through the steps of this. But one is to file the petition. If your spouse is still in the US, when your petition is approved, then we monitor the priority date. Once priority date becomes current, and even if it's the I-130 isn't approved, once priority date becomes current, your spouse is still here on a current and valid H-2B, then we jump and file the adjustment of status to go with the pending I-130. And then it turns into an adjustment of status process, and your spouse can get the work permit and the travel document. But timing is essential. If you don't follow the timing, it can turn disastrous. I've seen it happen to couples. So definitely in this case, you can't, there's no room for errors. So get it, make sure you call us, talk to us about your goals, and we can guide you through it. And we monitor and then file the documents as soon as it's appropriate. Student for over 5 years now on a sponsored job while being a student, want to file for myself. Can I? If you qualify through the national interest waiver, extraordinary ability, those are some ways. Investment visas or an investment green card could be a way. It just depends on what your circumstances are and how you qualify. My prima facie determination is expired for 6 months. What I have to do? So usually they'll issue a new one automatically. There's really no action. If I find that a client's prima facie hasn't come right after it's expired, I usually contact the hotline. So they do have hotline for attorneys. And, what I have noticed is then it will just come. The new one will just come. So maybe sometimes it got lost in the mail or something was overlooked and it wasn't issued. It usually triggers them to send it. I'm F4 Mexico 1999, did my adjustment in 2022. How long do I have to wait to receive my green card? Adjustment should not take. So if you did it in 2022, the adjustment of status part shouldn't be too long. It shouldn't be more. I mean, on average, I've seen maybe a year and a half to 2 years. So I would have to understand what process you did, whether you qualified, what happened, in order to advise further. We have no problems if I don't come with joint property documents on my interview. So it's not a one size fits all. Not all. No, I would say a majority of the couples that I represent did not have joint property, and everything went fine. But however, it's not. It's because I don't look at them and say, "Oh, no joint property. Oh boy, you're not gonna get through this." I say, "Well, what do you have? As a married couple, what are you doing? What are you focusing? What are the goals you're focusing on right now?" And that tends to help focus on the effective evidence, the evidence that's going to get a client approved. So just get in touch with us. Can my Irish wife move here and work while we wait for I-130 form? It's been 10 months filed apart. No, your spouse can't come with the intention of staying. They actually can see that as misrepresentation or fraud, because when your spouse is coming in, I don't know if Ireland, I think they do have ESTA, where you don't need a visa. But coming in, nobody with that's coming in on a temporary status or visa should be thinking as they're coming in or intending as they're coming in to stay. And so if that's the intention of your spouse, you're going to run into major problems. So keep that in mind. Now I've had represented couples that the couple came here, the immigrant spouse came here. They came to visit, but then guess what? They changed their minds and they said, I want to stay here and I just want to be with you. Then went through the adjustment of status process, right? So there's a difference. They didn't come in, they didn't walk through the airport saying, "Oh, I'm coming here to stay and I'm on my ESTA or I'm on the visa, but I'm coming here to stay." They came intending to come temporarily and change their minds, and they're totally entitled to do that. So in that case, everything usually works out fine because the officer, understands. Sometimes the officer will ask, when you're coming in, did you intend to stay? And, at that point, you have to explain. Sometimes the officer even maybe wants a little evidence. to show, that there was more of a change of circumstances or a change of heart that caused you to stay. So another thing is applying within 90 days of your entry can trigger that line of questioning. Applying, getting married within 90 days of your entry can trigger that too. So in that case, you need to make sure that you are, just that you're mindful and that you understand those. So once again, that's why it's important to have an attorney, because these are things that you don't see. You see always, oh, just get married and get your green card, but you don't see all these nuances that can create real problems. Pending I-45, valid EAD, and advanced parole, can I travel within the U.S.? If current EAD, a current advanced parole, that's what it's there for. And you're within the US, that I would say that's much safer than being outside of the US. If I get married to a green card holder while in the US on a visitor's visa, what are my options? So you need to talk to us. I cannot stress that enough. It's really when it comes to being married to a green card holder, I would say you may have options, but at the same time, I may advise, I may have to tell you you're not gonna make it, right? It's when it comes to being married to a green card holder, it's very strategic, and timing is everything. So to make it possible to understand the options and to be able to maybe approach it strategically, you need to talk to us. That's where I'm like, doing the live I can't do it in the live because I will not be able to get to the strategic parts, right? To explain to you, you know, ask you questions, figure out what your goals are, how long you're going to be here, what visa do you have, look at the priority dates to say, okay, priority date is this, you have so much time left here, are you going to make the priority date? So, or is that a possibility? Or if that doesn't happen, when do you have to go back home? So these are the things that we can't reduce to our life. Like, as much as I try to give you information, a lot of information, sometimes it just comes down to talking to an attorney that understands and can guide you through it step by step. Infidelity apply for VAWA. I would say no, infidelity alone does not qualify for VAWA. However, in most of my cases where there is infidelity, there is usually a pattern of mistreatment. There's, the infidelity is used as a tool. It's used as a way to disrespect our clients. It's used as a way to put them down, to manipulate them, to hurt them. And so in those cases where they blatantly use infidelity as a way to get back at them, it does qualify for VAWA because it's emotional abuse. Yes, I agree with you, Gypsy Soul, 100%. Attorneys understand understand the process. You get an experienced attorney, and they will be able to really walk you through the process. And that's one of the things that we do that make us stand out, is we really hold our clients' hands through the process. A lot of it, of course, we have to work together, but we take the lead when it comes on to filing procedural requirements, making sure everything is lined up, advocating for our clients when it's needed before immigration and before immigration court. So that layer of protection that you have, that layer that is sort of like insurance, it helps keep you keep your risk of complications lower. Can a 10-year green card holder parent file for out of status children in the USA in 19 and 17? Unfortunately, not. They will not get their green card since they've already overstayed. They will not qualify for their green card. If you become a US citizen before they turn 21, then they do have you can then change that I-130 to one filed by a US citizen, and in that case, they would qualify. So you'd have to become a US citizen. Now, keep in mind, guys, that I always approach this in a solution oriented way. If you're a green card holder, you have children who are here who are out of status, it does not mean that all hope is lost if you have a pending application. But what I would say, there is the I-601A process, and I know that process, if you know what it is, it's really nerve-wracking to think about, but that process is still going through. We got an I-601A waiver approval just in the past 2 months. So it's those, now with the I-601A waiver, it allows forgiveness for an overstay, and then allows them to go to the embassy, get their interview at the embassy in their country, and they won't hold the overstay against them. But you have to be very careful with it, because if there's any other issues in your background, then that's where the risk, of something really devastating happens. Like, a lot of people say, what if I go and I get stuck? Well, if you have an overstay, you got it forgiven with an I-601A waiver, but you have a whole other set of inadmissibilities. Maybe you have an arrest, or maybe you have misrepresentation or fraud. That I-601A waiver process is not going to work. So there are ways, but if you qualify for citizenship right now, probably is to go through citizenship and then change the I-130 to that of a US citizen petitioning for their children, just as long as they're not over 21. They haven't reached 21 yet. Is undocumented child abuse victim can apply for a U visa, and do they need guardian to file? So give us a call. There may be multiple options here. So we want to hear from you. We want to talk to you about if this is your child. We want to talk to you because there are multiple options that we can talk about. There's SIJS, possible T, possible U, possible VAWA, just depending on the circumstances. So now we're 24/7, guys. The phones are 24/7. Sometimes I will, in the middle of the night, as you can see, it's like 11:45. So, I stay up late sometimes. I look at my phone, and I do see that we do bookings even in the middle of the night now. So if you're thinking about your immigration situation 3 in the morning, you can call us and you will get a staff member, right? We're a close-knit team, and we are all invested in making sure that people are getting help at any time of the day, no matter where you are. If you're in the US, outside of the US, all 50 states, they're there answering the phones 24/7. So you can call right now and you'll be able to talk to our team member, and they can schedule you. Our schedule is filling up, and that's one of the things is we have only a limited amount of time. So please get on our schedule, because we want to help you as soon as possible. Is it possible to get EB3 green card via consular processing instead of AOS? Absolutely, yes. You can still do it through consular processing. And if you're here, you most times you cannot overstay and do adjustment of. There are few exceptions, but most, like 245I, that's a whole other life, guys. But some people can still qualify for Section 245I, which in those cases, if you're here without your papers, you qualify for an exception and you're doing employment based, you could apply, right? But in many cases, if you overstayed, employment is not going to work if you already overstayed, and you do have to consider going back to your country and waiting for the process. The process usually takes, I would say right now, about 2.5 years for the EB3 if you're outside of the US, and maybe shorter. So we were seeing shorter labor certifications going out. So instead of 18 months or a year, we started to see 6 months. And that means once you have the labor certification, 6 months, then you do the petition. The employer files a petition. That could be another, say, 6 months to a year. You're looking at maybe a year and a half instead of a 2 to 2.5 year process. So, absolutely. My immigration case was with the, I'm not sure what that says, STC. I'm not sure what that is. ST and then CRY. I'm sorry, I'm blanking out on that. I don't know what that is. If you want to spell it out for me. How long they take to process the I-693? Sent them mine in May, nothing yet. I've seen it anywhere from 4 months to even up to a year to process that. How long does it take? And the I-693 is the medical, the sealed medical that they ask for in the RFE. How long does it take to get a green card holder filing for a child who is 20 years old? Child is out of the US. So now you do have to wait for the priority date to become current. So it depends on the priority date. But I would say if I have to estimate based on our experiences, maybe 2 to 3 years. Do you help with asylum? Not only do we help with asylum, we do win those asylum cases. So absolutely, we have work permits coming in for asylum clients. And we have approval. So we have one on even as recent as August 1st for asylum, and official asylum approval after an interview. And this is where, guys, I say, don't look at the interview. Well, it's gonna feel like doom and gloom if you're not prepared for an interview. But when that interview comes, we snap into shape, we get our clients into shape because we see it as an opportunity. We don't say, oh my gosh, why did we get it so soon or so soon? We say, oh my gosh, our client can possibly have whatever we applied for sooner than we thought, right? So when they're doing the interview, they are still giving you an opportunity. It's not doom or gloom. So don't treat it that way. Don't be negative. Go in there to show you qualify for what you're applying for. My father was just detained, but was approved for I-130. Is in an asylum. I'm so sorry that happened. Give us a call. I know, like initially, with this process, with when a relative is detained, it feels like the whole world is crashing. I know, because we are really fighting for clients right now, and we understand the challenges, especially for the family. But the first thing we need to do is figure out what's happening. There are possibilities for possible bond, but we need to understand the circumstances. We need to understand, it does the I-130, if it was approved, then how can we move forward from there? Is there an adjustment of status process that we can bring to the judge to say, look, client qualifies for adjustment of status, so can we get the case terminated? We need to understand. So give us a call and let's talk. As I said, we're 24/7. Give us a call and let's get to it, right? But I am so sorry that this is happening. Did our green card interview since June 16th, yet no decision. So they may be looking into things. How did it go? So that's my usual first question. If you've been waiting since June 16th, the next thing I want to know is how did it go, right? because usually we get the answer much sooner. Usually my marriage-based green cards, I know there's, as things get more challenging, things might take longer. I always go in saying, okay, maybe we might have to wait a little longer, right, for a decision after the interview. But we prepare our clients so well, we usually get that approval within a day. I don't think we've even gone a week without getting that approval. We usually get a hint at the interview that everything is, and when that happens, we usually know based on the officer's responses, right? Based on the way what the officer is saying, we know that, okay, it went well. So, how did your interview go? And once I hear that part, then I can know, okay, that went bad, and they're probably looking further into things. They're maybe doing extra background checks and so forth. So, I get married last month. Can I file my green card? That was what we just talked about. I technically yes, but are you ready? Are you ready? Do you have everything ready? Because that's where it's going to determine your approval. It's not how fast you file it, it's how ready are you, how prepared, how thorough were you, how detailed were you with your evidence. And guys, I was just talking to my team today, and that's what we were talking about. The fact that our team has been successful because we focus a lot on detail. Sometimes our clients, when we're working with our clients, even our clients are like, oh my gosh, why are you just so much on the detail? Because guys, that's where the approval is. It's in the detail. You don't get that detail right, then the officers will, if there are gaps, if the officers have questions, you're not addressing questions that they're asking, that's going to lead to a request for evidence or a straight up denial. It's in the details, right? It's in our knowledge of the law and how the evidence attaches to the law and the requirements. So just keep that in mind, that filing this is not just about showing us marriage certificate. It's about the evidence, the details in the evidence. That's why yesterday when I was talking about evidence, if we want to talk more about that, it's in the details. What do I mean by that? You could submit something that you think is solid evidence of your marriage, your real marriage. You could submit a bank statement, right? You're like, oh my gosh, this is a joint bank statement. We check that box off, right? Because don't they want joint bank statements? And you think it's okay, except you've just created a red flag for yourself because it's an empty bank statement, meaning your bank, you have a joint bank account with your spouse, but it's completely empty. You maybe put $5 in to open the bank account, and you never added money to it. And then worse, maybe you drew the $5 out or overdraft the $5 and they never put anything back in. That's a red flag, actually, right? So there's a difference. It's not just about checking off the boxes. There is a lack of detail there. Okay, we see you have a joint bank account, but that's not telling us anything. That's telling us you have an empty bank account. So how is that telling us that you're sharing finances with your spouse? You're sharing financial responsibilities. You're saving money together. How is that telling us whether you're building a life together? It doesn't say anything. It doesn't give any detail. Versus a bank that's showing all the transactions between spouses. It's showing they're paying bills. It's showing their names all over it. They're showing them selling each other back and forth. These are things that make the difference, right? So it's in the details. Is it possible to win a BIA appeal case? What is the success rate and how long does the process take? It is possible. Success rate, I don't have that information, But here's another thing I wanted to let you know is, and this is actually an update. So they are, um, for court, they have fired over 100 judges, immigration judges, and they're now putting military judges in place and attorneys who have no experience in immigration law. So I do anticipate there's going to be a lot of appeals, because if you have inexperienced people that have no knowledge of the law doing this, it's a disaster. It's going to be a disaster. There are going to be unnecessary denials, unjustified denials, and where the wins may be is in the appeals, right? So I would say that we need to gear up for that. So that is something that came to mind when the news hit. I'm like, appeals is where it's gonna be now. We need to be ready to file appeals, because if, and another thing is going through the process now. A part of going before an immigration judge or is to sometimes be able to walk the judge clearly through the law and why your client qualifies for it, and to do it effectively, right? So sometimes presenting it almost like you're a teacher, right? Showing the judge this is the law, and just making it plain as day to the judge so that they can see it clearly as well. It's going to have to be a lot of that approach, and it's going to be in the appeals. So keep that in mind. It's alarming, and we're going to be seeing denounce, but the appeals, there are appeals, right? There are ways to fight. And here's another thing. I know some of us won't be able to stay out of immigration court. However, where you can avoid it, you know, try to figure out if there are options. And that's what we're doing. We're trying to be proactive to help people to find options before they end up in there, because it gets more complicated, right? It gets more stressful. TPS Nepal, what should I do next? So, asylum, here is it. If you're losing TPS, which that's another thing, I'm going to send a newsletter out, about the updates going on. So that's coming out soon, probably tomorrow, because it's already noon. Good morning. I'm not noon, it's midnight. So good morning, everybody. But what we have to do is, I'm going to release that tomorrow, but what's happening is they've ended TPS for Venezuelans. And I say, if you are losing TPS, good morning. If you're losing TPS and you're losing parole, then it does not mean you don't qualify for asylum. And you may very well qualify for asylum because you have new circumstances, right? You've fallen out of status. Now you're in true danger. You've had a change of circumstances. So give us a call. Talk to us. If you're losing your TPS, you're losing your parole, it does not mean that you don't have options, right? And proactively submitting an asylum can possibly keep you out of court as well. But guys, for some people, the fight may be in the court. And strategically, now I'm thinking appeals might have to be the next thing that everybody is prepared to do. Is it okay to travel with conditional green card? Green card holders can travel. Absolutely, that's there's a right to travel. If you're concerned about something in your background, that's where you need to get in touch. My marriage-based interview was in the 1st of July, and they said they will reply within 30 days, but they didn't. Check on your case. That's very common. So check on your case and see if they sent anything, if something got lost. All right. What about spouse on deployment? If so, the spouse is on deployment, they can use their discretion to waive the spouse's appearance at your interview. So very important you let them know that in advance so that they can possibly make that accommodation. Also, keep in mind that that may also be a reason to expedite. If your spouse is about to be deployed, you may be able to request an expedite of your green card application. Good night. Like, what question would they ask my 12-year-old son? My husband petition on me and him. So, when it comes to children, they're only looking at, what's the parent, do they qualify in terms of the parent child relationship? Is there no fraud? And is your son admissible? So they're going to stay in line with the application. They're going to look at the evidence, make sure it all looks good. But it shouldn't be as heavy as a marriage based, unless no, they're not, they may not drill your 12-year-old. They may have questions about the relationship. If your 12-year-old is the stepchild of your husband, then they may look at the relationship, your relationship, to see. So, they may focus on that to determine whether they're going to approve your sons. Hello, I'm filing the I-751 form. There are many questions that are not applicable to me. Do I leave all these as blank spaces, or I need to enter an A? So I don't advise on forms, especially what you should say. This is where I say, if you're doing that, it's time to get an attorney. Do not fill that out by yourself. If you have no idea what to put. I'm here at work watching you live YouTube. It means a lot. Well, thank you. I thank you for being here. And I know some people are on the night shift, you're working. I appreciate you taking the time to watch this and get information and share it. And yeah, I'm grateful to be here as well. U.S. citizen parent sponsor adults. I think I answered these already. Okay, so I'm back on Instagram, and then I'm gonna go to my bed, everybody. Um, can I file a marriage-based petition if I was denied my 2-year waiver? So, if you went from a 2-year green card to a 10-year you were applying and then they denied you your 2-year. Now, this may be a complex situation. Give us a call, because it may be a situation where I have to find out, did they send a notice to appear already? If not, then it because if not, you've lost your green card status, and usually the next step is they're sending it to removal. So, we have to figure out strategically what the best option is for you here. A marriage-based process, maybe, but I need to figure out, are you already in removal? Because the marriage-based petition may not fix that. So yeah. Can you still get married if you have a deportation order? If you have no, if you get married, it's not gonna fix it. You're at a high risk too. It's not gonna fix the situation. You'd have to go back to court. So we have to figure out, okay, what happened? Why did you have a deportation order? Then go back to the court and see if we can get it reopened and terminated, and then you would be able to move forward with the adjustment of status process. So it's a complex process, but if you are married to a U.S. citizen, this is your legal option, and you're at high risk for detention and immediate removal because you already have a deportation order. So you need to be proactive on this for sure. Is a child abused by his undocumented parents qualified for U visa? Who is going to apply on their behalf? So they are qualified for multiple options. I can tell by this. Give us a call. Let's talk. There's SIJS possibility. There's U visa. There's T visa. So give us a call. Let's talk to see. I need details to determine the best option going forward. How long and what happens, say for U visa, the child applies, we apply on behalf of the child, their guardian would sign on their behalf if they're under 14. So how long does it take to receive EAD with marriage green card? So I've seen as little as 2 weeks, on average, 3 to 6 months. The last one we got was within 2 months. How long to receive BFD and T visa case after submitted? So I would say, based on the time it's taking for receipt notice, it can range anywhere from 3 months. I've seen as short as 3 months, but now I'm seeing as long as 8 months, just because it takes 3 to 4 months alone to get the receipt notice, then the biometrics, then the BFD. Can a botched asylum case be salvaged? Previous lawyer didn't make any statement, just a line of domestic violence. Sorry. We have to understand, why is it botched? Did you go to the interview and because I'd have to understand what happened. Because is it botched, or is it just need to add additional documents? So yeah. If I get my green card by marital status, what can I do to get my grandchildren? So you can't file for your grandchildren. So that's the thing. If your case is abroad with NVC, does the lawyer do anything to speed up the process? Only in cases where there's you have to, there are certain things with NVC, they usually want to see some kind of medical emergency or humanitarian crisis. So you have to show evidence of that. Otherwise, they're pretty tough. It's pretty tough to get it expedited. How long does an EB3 visa usually take? So anywhere from, I would say, 2.5 years. Oh, thank you so much, Aline. I really appreciate you being here, and I enjoy sharing this information. And it's not just sharing, but it empowers immigrants to understand how to approach their situation, and that's important now. What is the current processing time for a marriage green card? So I am noticing that, and keep in mind, as they get into the real nitty gritty of things, it might get longer, but I'm noticing interviews are being scheduled quickly. So me and Attorney Deanna were talking about that, how quickly interviews are being scheduled. So, it could be a matter of months. But on average, I'll tell you, on average, about a year to a year and a half for the marriage-based green card. But interviews are coming quickly. And if you do well on your interview, along with a solid application, you could have your green card in months and not a year. So keep that in mind. And that's the thing too, is you file it. In our experience, when I file, I spend the time to submit a solid application, and the rewards of that really show in how quickly the application goes up. The client, well, they were waiving interviews at one point, but before they were waiving interviews, we would get a green cards in like 4 months, 4 to 6 months for marriage base. So, it definitely is rewarding to submit an application that is thorough and detailed. Is BFD for T approximately how long? So I think I answered that already. My US citizen husband filed for my 13-year-old daughter in May 2025. How long will the process take to be approved? So I would say, expect about a year. Well, I think you said she was outside. I don't know if we answered this already. All right, I am so tempted to answer more questions, but I have to go to sleep or I will not be able to function tomorrow. So thanks again, everybody, for your time, your questions. These are all great questions. Um, Go ahead, like, subscribe, share, hit the notification bell. That's how people are going to see this information. They're going to be empowered in their immigration journey and they're going to know where to get help. Now, if you have questions specific to yourself, you can call right now. Call our number. It's all over my videos. It's going across the screen on YouTube, Facebook, and Instagram. Just call that number. We have a team member right now who is waiting for your call and who will go ahead and schedule you right on the spot if you're ready to talk to us, to get to solutions, to get to your goals, to be able to really, you know, make it happen. It is possible, guys. The challenge is harder. Yes, the challenge, it's definitely a harder situation to be in. But I say this, we're meeting the challenge. We're rising to the challenge. We're not cowering down. We look at the law, what's required. We look at our clients who are qualified and we say, they're qualified. We just need to rise to that challenge, right? And it's working because we are getting approval still. Okay, so keep that in mind. Thank you again, everybody, for your time, and I will see you tomorrow. Take care, and let's have faith and take action. All right, bye bye.